मथुरा से द्वारका जाने के बाद जब एक दिन कृष्ण बांसुरी बजा रहे थे तो माया भ्रमित होकर उन्होंने ये बांसुरी यहीं छोड़ दी। ये हमारे गांव वालों का कहना है और उनका विश्वास है।
मैन्युस्क्रिप्ट में ये जो इन्फॉर्मेशन है उसका चित्र बना के बाद हमें एक बात की जानकारी मिली। ये देखो, इस दरवाजे पे जो सांप है वो है कालिंगा। माना जाता है कि कृष्ण भगवान जब यमुना नदी में उतरे थे तब उन्होंने इस सांप के सर पर नृत्य किया था और अभी भी वही सांप इस कृष्ण मंदिर में उस खजाने की रक्षा करता है, ऐसा गांव वालों का मानना है। ये जो सीक्रेट दरवाजा है वो पत्थरों से बंद है और जब गरुड़ा मंत्र पढ़ते हैं तो वो अपने आप खुल जाता है। और ये गरुड़ा मंत्र कृष्ण परायकर के परिवार को और कुछ सिद्ध लोगों को ही पता है।
तो ये उनसे ही पूछ लेते हैं, है ना?
घर में चोरी करने के लिए घर के मालिक से ही चाबी मांग लोगे क्या?
तो दरवाजा तोड़ देते हैं।
जो ये कह रहा हूँ ना,
वरना तुम्हारा मुंह तोड़ना पड़ेगा।
कुछ गलत हो गया क्या? इसका कोई और दूसरा तरीका तो होगा ना?
हाँ है, ये देखो,
व्यू का चक्र, इट इज द की।
सेंटर में जूम करके देखो,
वही नाग बंधन है। अगर व्यू का चक्र को इसमें लगाया तो डोर ओपन होगा।
ये व्यू चक्र मंदिर में ही कहीं है और उसका क्लू हमें ही ढूंढना होगा।
इससे अच्छा तो बैंक से लोन लेकर सेटल हो जाते हैं।
तो प्लान कब एग्जीक्यूट करना है?
7 दिन के बाद सूर्य ग्रहण आने वाला है और उस दिन मंदिर बंद होगा। हम उसी रात वहां जाएंगे।
कौन सा मम्मी? कौन सा?
इस बारे में हमें डिटेल में काम करना है, इसलिए कल हम फिर से मिलेंगे। ओके?
ठीक है।
इधर क्या हुआ अर्जुन? नहीं, कुछ भी नहीं।
हाँ बहन, मेल आ गया।
मैंने जो बोला सब याद तो है। सब कुछ लूट ही जा रहा है।
नहीं, तेरे पास आ गया।
हजारों साल पुरानी एक बांसुरी रखी हुई है।
हाँ, जो
इस टीम को ऐसा लगता है कि वहाँ पर सिर्फ खजाना है। तुम सिर्फ उस बांसुरी को बचाने का तरीका निकालो। अगर कोई बीच में आया तो मैं देखूंगा।
अरे लाइव स्ट्रीमिंग, मेरा लैपटॉप खराब हो गया था ना, तो अब उस पर लाइव स्ट्रीमिंग करनी थी तो अब मुझे मिल नहीं पा रहा था।
फ्लूट निकालने दो।
चलो शुक्र है, हो गया लाइव।
और उसके बाद उसकी कहानी खत्म हो गई।
नहीं, अभी नहीं आया, आज फॉर्म सबमिट होगा। सॉरी हो, चल मैं खाना खा लूँ फिर करती हूँ ना। सोचता छो जा दीदी, छो जा।
Have you reached Colombo? I'm already here.
9 बजे उठ गई थी, आज के पापा की जल्दी ही शिफ्ट।
It's just an overnight journey for me. We'll move on with that.
Therefore, it is actually upwards. My options available. 4 options here. So then kindly turn left.
ये सिर्फ एक 80
Article 163 in the in the state, it provides there shall be a council of ministers with chief minister
मंदिर के अंदर एक बांसुरी
elected control by the he is by under the constitution
उसके लिए वो खुद यहाँ पर
or
आए
any other not to make the governor signing
कभी फालतू चीजों पर
and
विश्वास
shall be barred any person
तुम विश्वास नहीं करो
what
उसका विश्वास करो
Thus, with the text of governor norm acts in the
जैसे
by the constitution
उससे
itself
मेरे पास
enters him with an independent and 200 is an instant just the article then kindly the page 470 the constitution is very limited. The field where a governor may act, for example, article 239 of a neighboring jurisdiction can do independent special provision 6 schedule article 317 particular to others expected 365 the authority governor is satisfied state government consent constitution may report to the president government possibilities even if it's minister like the 200 the limitation then it comes to the next page at 12 and speaking to address them suppose kindly sir
ये उससे देवराज ये बता सर आप जरा बाहर ये यहाँ की
68 in
ऑफिसर बाहर नहीं जा सकते हैं सर हम आपको बुलाएंगे
with position of law
सर आप कैमरा क्या चाहते हो सरकार
66
मंदिर में रंग छुपे हुए खजाने का पता चला है उसमें से कुछ माल चुरा लिया गया है
but left the governor the 42nd amendment bill article 74
से कुछ लोग चेक करने आपको उन्हें
the 44 amendment that added the proviso of
ये कार्यवाही सरकार की तरफ से है तो सब कुछ सरकार का है जो भी मिलेगा उसका 10% गवर्नमेंट को दे देगी और बचा हुआ 90% हमें दे देगा उसमें से आप पैसा आपको मिल जाएगा सब कुछ अकेले ही अपने के बारे में मत सोचना बिना हमारे सपोर्ट के कुछ नहीं होगा आई बात समझ में तो मैं चलूँ नमस्ते
the governor continues the original except there are article 200 other provisions 63 independent now come to the article 68 this position of law is clear we stated the least
अब मिनिस्टर को बोल के आपको एक अवार्ड भी दिलवा
and
दूंगा
later explained
अवार्ड का क्या करेंगे
the governor
मंदिर बस तो है यही काफी है
that we
वो सब टेंशन नहीं है ऐसा नहीं होगा मिनिस्टर साहब निकल रहे हैं
which is module B3 15
इतने दिनों से जो मेहनत किया सब वेस्ट हो गया अगर रेवेन्यू डिपार्टमेंट ने सीज कर दिया तो कुछ नहीं कर पाएंगे
अब एक ही रास्ता बचा है हम आज रात को ही एग्जीक्यूट करते हैं
6 बजे के बाद उस मंदिर में कोई पूजा करने भी नहीं जाता है और तुम चोरी करने की बात कर रही हो
तुम इस पर विश्वास करते हो
100% करना हूँ
थाउजेंड्स ऑफ क्रोर्स के
वो चाहे जितना भी हो और उसके लिए जिम्मा तो होना चाहिए ना तुम लोग जाओ मैं नहीं आऊँगा ठीक है
ये बात जो डर गया ये अगर आज रात रिस्क नहीं लिया तो जिंदगी भर मिट्टी को रह जाएंगे मैं तो जाऊंगा
देखो जब समय हो जाएंगे तो वहाँ से बाहर सबको सेव करने की सुविधा नहीं होगी मैं सबकी गारंटी ले रहा हूँ अंदर सब एंटिक्स वर्ष के निकलने में कुछ नहीं सका तो यहाँ सारे लोगों को जेल जाना पड़ेगा
I don't propose to read
ऐसे ऐसे बात करता हूँ उसे कल ही उनको बता खजाना कभी उसके हाथों में देते बाकी सब वो देखिएगा 2 महीने तक हम हमारा यूजुअल काम करेंगे उसके बाद सब हो जाएंगे अब क्यों भी तो हमारे पास नहीं है
वो हमें अंदर जाकर ही पता लगना पड़ेगा शाम को 6 बजे के बाद मंदिर में कोई भी नहीं मिलता है उसके बाद सीधे सुबह 6 बजे खुलेगा पूरे 12 घंटे उतने टाइम में हम लोग घूम नहीं सकते हैं
ये कितना बड़ा रिस्क होगा
इससे अच्छा आइडिया है तुम्हारे पास
Exactly.
I want to judge these couple of paragraphs only because of connecting already in the context of
तुम लोग काम खत्म करके डायरेक्ट गोडाउन आ जाओ, किसी को डाउट नहीं होना चाहिए। सो मैं वासुदेव के साथ रहकर उस स्पेशल टीम को जितना डिले कर सकता हूँ करूँगा। काम खत्म होते ही डायरेक्ट वहाँ आता हूँ। ओके?
it's clear that if a bill pending the assent of the government or the president is held to tax on the usage of the it is not unlikely that a prior bill will be passed or the assembly will be announced to be exposed to the consequences.
अर्जुन, तुमने जो साउंड चिप लगा था इस डिवाइस के अंदर है, सेंस लगाओ बराबर सुबह 6 बजे स्पॉट में पहुंच जाएगा। मैं और वासुदेव जब सूर्य मंदिर में जाएंगे तो वहाँ से
significant that neither party will go back for a time
और उसके बाद तुम्हारा भी काम
on the bill to come where it appears necessary to keep a time of the consequences
ओके
Article 191 In fact, the proviso of Article 201 the House with the bill reputable session to reconsider accordingly the date of the there was a failure to make a provision as to the time the governor may suggest that the constitution makers that bill which is pending to send to the governor or the president may not stand as that is why no time limit was prescribed in Article 201. Therefore, in opinion, suppose the conclusion of the the court is alive to the right mandate of the constitution and if at all in and subjugate now under individual I'm extracted etc. I said I will not lost the point of view. Let me quickly read one more
वेस्ट साइड से आना शुरू हो जाएगी और ये जो सेंसिटिव डिवाइस है उसे हम उसे कैंसिल कर सकते हैं। कैसे? ठीक 12 बजे ये ऑन हो जाएगा। जो भी साउंड सिग्नल्स आएंगे वो नेगेटिव साउंड सिग्नल्स को कैंसिल करेंगे। रीड अगर कोई भी सिग्नल डिटेक्ट नहीं हुआ तो ये डिवाइस
कॉल द मीन आई हो जाएगा।
अपने साथ क्या करेगा वरना फोन का रेडिएशन एडवर्स इफेक्ट दे सकता है। जो भी लेवल आपकी जिम्मेदारी होगी
के 5 से 3 मॉर्निंग 6 बजे मंदिर के अंदर कुछ भी हो जाए मैं just read only one paragraph, 2 paragraphs.
सारे काम के सामान आपके सामने रखोगे। ओके
Begin session 3776 paragraph 90. Governor is our very important part of the legislation of the state under Article 4. This is volume V9. The governor is our made a competent part of the legislature of the state under Article 160 because every bill passed in the state legislature must be reserved for the attention of the Assembly. Another article, the governor will not one of the people of the Assembly. If they give his assent, it will become the law. Except in the case of manual reform in which case the bill falls through the procedure indicated, very important, in which case the bill falls through under the procedure indicated in the first That is, return the bill to the assembly for reconsideration, or he may subject to ministerial advice to reserve bill for the central session, in which case the president adopts the decision under Article 201. The first proviso of the Article 201 deals with the question. So the governor is bound to instruct the bill be considered and pass it to the assembly. The second proviso on just skipping it, just 2 lines later, that is clear that the bill passed by state assembly second if the governor gives assembly, or if it being reserved by the governor, it is absent to the assembly. The governor is therefore free from the state of the state. So only other functions. But what is important in this paragraph is in the middle of it where it is that in case the bill comes to pass fourth line, second para 1 to subpara 1, he may, except in the case of the money bill, withhold his assent therefrom. In this case, the bill falls through. In this case, the bill falls through unless the procedure indicated. This is the reasoning here. So, Valluri was saying, which ways it will fall through unless the procedure to the provision. I specifically try to explain the reason of the convention. These will probably think that one of the terminology that will talk. So this is one thing I want to say. Then I will take a look at some shades here. It is V7. Begins at page 288.
ऐसा कुछ भी नहीं है, सब जो बोला है वो काम करो.
2903. The provisions of the Constitution.
वही जहाँ होती है वहाँ की कैप्चर की फोटोज हैं. इसका मतलब है जैसे नदी का पार करके हम शिव को देख सकते हैं, वैसे ही गरुड़ को पार करके कृष्ण को देख सकते
The
हैं.
governor gets through the referendum to illustrate Article 2 pertaining to the state of and administration of the foreign union territory. He shall exercise his functions and actions that independent of responsibility. The other articles which speak of the history of the government, paragraphs 9 to 18, articles
Mogana,
the
Mogan.
the governor being that is the constitutional or formal head of the state. The power is vested in him. In this connection, the government the article papers the
Hello?
governor and the
रविराज आपने वर्क इंडिया पे फील्ड सेल्स की जॉब के लिए अप्लाई किया है. आपने वर्क इंडिया पे फील्ड सेल्स की जॉब के लिए अप्लाई किया है.
which in his opinion is
पेटीएम में फील्ड सेल्स की जॉब है. आप इंटरेस्टेड हैं?
another instance of the government act irrespective of the age.
मुजफ्फरपुर से है ना आप?
In such matter, the governor is to exercise the
हाँ. तो मुजफ्फरपुर से ही है.
The governor is required to pursue such which is not legitimate. Again, a larger bench. I just
नहीं ये पेटीएम में है फील्ड सेल्स की जॉब.
questions 13 and 10, page 516.
अच्छा आपकी बात हो गई है.
I will not indicate page 516. Yes, they are clubbed up question number 13 and 10.
ओके. चलिए ठीक है, यानी कि आपसे बात हो गई है. अच्छा चलिए ठीक है. कुछ और होता है सैलरी में तो बता. क्या हो गया नूनू? इसी सुनो हैं?
or the power of the source is going to article 140 limited to matters and issues, or do they excel in issues directions of knowledge or inconsistent statements in substantive or procedural solutions or other logical sources? And question number 10. When the exercise of the constitutional powers is ordered or the procedures of the governor be substituted in any manner in the questions 10 and 13 are both related to the government powers and Article 140. The response to question number 13 will be answered. I don't read Article 140. You know what? Except saying complete justice and cause the matter of it. The rule of inherent is the rule of inherent if the law gives anything to anyone, it gives also all those things that people think itself or take. The power cannot exceed own authority beyond its own creation. It is not that a person is heavily loved, when the person is heavily loved. On the contrary, the concept of heavily has been severely inherent powers can be exercised only to support and secure the interests of others. The scope and extent of the power law several positions. It will be opposite to first state, the right position of the power of the court or wide and repeat. However, the power is primarily a supplementary one for the purpose of doing complete justice and fitly played is supplementary, not supplementary to the stated in the regular thing. Therefore, the qualifying feature of the Article 140 can be said to be the express statutory provision of the court and relief is inconsistent against substantial statutory provisions which will be granted. This has been emphasized time and again. This honorable court is Supreme Court of Association. Plenary powers are inherent in the court and complementary to the powers which are specifically conferred on the court by various statutes and wizards. These powers also exist independent of statutes. These powers are a wide amplitude and nature of supplementary. A supplementary to a complete or particular party is to the level where individual adjudication is not present the need to believe the need to have a complete justice. Then the court resolves this. Of course, we have traveled beyond that individual adjudication party. Court, right on violence, etc. But I suppose there are certain limitations. So, can you read it? These powers are a very wide and this power exists as separate independent later. This plenary jurisdiction is the citizen of the way draw upon a for in particular in India while administering the body. There is no doubt that it is irresistible against all the powers and freedom, the reference of and valuable lesson of the court given, blocking obstruction. It, however, needs to be the powers conferred in the court of being curated in nature as powers which authorize the court to secure the substantive rights when dealing with the constitution. Power cannot be used to substantive laws applicable to the case or cause under consideration. In Article 140, even with the exception to be the new edict where none existed earlier by including express statutory dealing with the subject and thereby to affect indirectly construction of Article 140 functionally informed and salutary purpose complete. Then the next paragraph, the very nature of the power, the three purposes of the statutory provision governance except whereas to balance equity between the functions of the agency. There will always be the government by ironing out the three. Now, kindly go to page 5 and 6. Not just get into they all talk at the same maybe how governance and what will be exercised, keeping in mind the balance required as a before entering into all feel where it so that's what we kindly turn over I have referred to few other judgments. You go back in point 30, you go back in same sentence. Page 138, what? Power is restored in order to divide and intended and always be applied in general. That is not to say that order can be made to it is incapable of ultimate transparency. An order that the court can make in must not only be consistent but it cannot be inconsistent. I only then same speed we have another thing of next at pages 519 and 520 we have in state of Punjab is Ravinder Singh at page 519 bottom paragraph 690 it's a recent judgment the affirmative actions of the state have to be within the constitutional framework and if they are not the court cannot ratify the state by bending or molding the specific mandates and framework of the constitution not telling the copy to even if it is a bit kindly so number 2 page 521 kindly see Karnataka no even the top of that 693.9 the actual state social intention of the violate if that is the logic, I do not know whether the one particular to when to do complete justice in precisely what is happening here. I only read a couple of paragraphs can you turn to page 5.1 the court has also said because there is a failure in part of the governor not acting according to the scheme of Article 200, the way the court read that, the court says, I am going to give a deemed justice. To answer the question on the Supreme Court itself being the existence and power cannot in external rules violence to the constitutional scheme which identifies specific roles of the executive, the legislature, the leader of the constitution or a statutory can still go for interpretation of the key was in Article 140 that's the thing matter sufficient guidelines even while exercising the within the confines of the transparency the sacred boundary power cannot be worked the license in place of the basic section and indirect either actively or passively by creating legal or premium fixes. For example, the grant of approval to the license of the means and the release tax to be fully implemented in the absence of exercise following the plan express relation to the voting so when voting on in the light of the the designated authorities the governor of the who are no other person including the
हाँ हाँ
So it can also not be done by inventing the idea that all to be there's a judgment in the Tamil Nadu judgment says reliance upon.
हम मंदिर में क्यों घूमे, लेकिन ये मंदिर ही एक क्लू है। मैं तो समझा नहीं बच्चों। अंजना वो लाइन जरा कैसे पढ़ूं तो?
पुनरुरे पुनर्मी न इद देवांगम तड़ा दक्करे वंदे हीनम न्याव मिसै पुलमेरुंदुम नर वेनयामितिल नीरमयल तेलिंदारिपिल सिरकल चंगुग गरुडालिल तू मणिमाड़ियार मुरसी मांदी तुत्ती मरड़ी मारु तुड़ित निसंगा गंधर्व।
ये क्या कर बंद करो फोन कर दो ऑन
यही व्यू
फोन कहाँ से करूँ
उन लोगों ने व्यू चक्र को एक जगह पर नहीं रखा, उसे तोड़कर अलग अलग जगह पर रखा हुआ।
ये कैसे बोल सकते हो?
सी ये लाइन क्या आते हैं वो जाकर करुण से निकले, उसके
हाँ,
बाद
हमें लग रही होंगी प्रेस
संगीत
में।
सुनते हैं। इसमें वो सोचना छोड़कर सिर्फ जगह के बारे में सोचेंगे।
थोड़ा गरुड़ संगति इसे मंडपम
मतलब कि इन तीन
हाँ तो वो डेली पीती है
So, shall we begin?
डेली बना के देती है उसे डेली बना के देती है
I was at the fifth line.
सुनो तुम नहीं आ रहे हो?
Judgment in
अभी नहीं मिला अभी तो इन्हें कुछ कुछ दिख रहा है
इन तीनों को जोड़ने वाला एक सेंटर पीस होना चाहिए, वो मैं दिखाऊं उसे। ये जगह का क्लू लिया, करुणा संगति, थोड़ा परेशान बन गया।
बहुत सारा खाना
317. The governor,
Wait.
Lord Chief Justice got it? One, 2, 4, 5, 4. Confusion. 34. So 34. May I read it?
Yes.
The governor under the constitutional scheme is no longer envisaged as the governor under the Government of India Act 1935, having the ultimate power to veto in legislation, subvert the collective will of the people, being expressed the legislature, is the power to withhold us. And finally, skip a few lines and come to a sentence running like this. It would have the potential of, that is, decide a course of action notwithstanding the aid and advice of the Council of Ministers. It would have the potential of turning him into a super constitutional figure, having the power to bring to a complete halt the operation of the legislative machinery of the state. The governor cannot be vested with such a power. The exercise of such would enable him to collude with the union cabinet. The two strong things to state. and to ensure that death of any and all legislation initiated by the state may be reserving for the consideration of the president, who is not under Article 2 and 1 is not bound to give assent to any legislature reserved for consideration. Then I read one para 434. 4378. Page 12561, paragraph 432. The conduct.
Paragraph 432.
432. 12561. The conduct exhibited on part of the governor, as it clearly appears from the events that have transpired even during the course of the present litigation, has been lacking bona fide. There have been clear instances where the governor has failed in showing due deference and respect to the judgments and directions of the court. In such a situation, difficult for us to repose our trust and remand the matter to the governor with the direction to dispose of the bills in accordance with the observation made by his judgment. Article 142 empowers this court to do complete justice on the facts of this case, more particularly in the light of the fact the option of granting assent to the repassed bills was the only constitutionally permissible option available to the governor. We deem it absolutely necessary and appropriate to grant that very relief by exercising our extraordinary powers. No meaningful purpose would be served by keeping the bills, some of which have been pending for incredibly long periods, pending for more time. Therefore, we deem the assent to have been granted. I don't propose to read all of them. Para 434 has a long list of conclusions, and the summary of the findings is available from page 12577. Page 12577 onwards.
125? 77.
Facts, but the facts which are noticed in 431, is it correct? Quickly, that 2020 bills are pending.
One.
He's asking if this is factually correct.
Yeah, that's factually correct. Let's say even if it's factually correct. But there are so many bills which were sent back so quickly. There are some bills which were not sent. That's the dynamics. In fact, I didn't want to go into the facts of that case because I appeared in it.
432 appears to be the reaction of 431.
There were certain explanations given to that, but the court rejects all that explanation. There are long reason why probably the governor kept them without giving his assent for a long time. So we are not going into those reasons. We're not talking about that particular conclusion drawn on those particular facts in the judgment. We are only talking about the state of law. And a state of law, will you say, I will invoke my 142 power and say, I'll give deemed assent. That has to be tested.
But 433 talks about the reason for exercising that power. Very detailed.
I thought, which paragraph?
433.
433.
I would have a nuanced argument on that. Dehorse the fact.
We are not asking your lordship to get into the any re-evaluation of those facts.
You don't want to go into the
revision,
facts.
etc. We are not asking that.
No.
That's a good question. The question is, given a certain set of facts, even though they are so
So glaring.
correct, right, no,
But in
not
this
palatable.
case, there is no pudding.
They're not
Proof of the
palatable. When
pudding.
you say, look here, I will enter into the shoes of so and so and do what the governor would have done. I mean, that is we are talking about a constitutional function. We are not talking about a diverse and a marriage, etc. It is very different field altogether. Only one more paragraph I would read and then leave it to your lordship's consideration of how to evaluate this table. Where's that? It must be in the judgment. I'm only presenting a broad overview of how certain disquieting features of the judgment, because now is a precedent. The judgment says I follow the Punjab state of Punjab case. It's one of the honorable judges of party to the Punjab case. Therefore, it is now the status of a precedent. And then how do you, that's why I told you last in the morning, I have so many judgments of the Supreme Court on my table. The president sees that.
Certainly, you also enlighten us
Yeah.
that if these are the facts before a constitutional court,
Yes.
431 and 433,
Yes.
and if, according to you, the court went wrong in 432, then what else should be the constitutional permissible recourse
No, the-
for a constitutional
Correct.
court to exercise
I quite see that.
jurisdiction?
That's what we're not asking the lordship to say whether the lordship may answer that question. If there is such a set of facts where the court probably has no other option, I ask myself a question: would the court still say, "I will do what the governor will do"? The court will again say probably why the governor must be asked to find out what is the best course of action which should you follow. It must send back to the governor in any circumstance. Then otherwise you're taking over the functions of a governor. It can be taken over in any circumstance in future. Like no limits can be drawn, no lines can be drawn.
But in 532, there is also finding that there have been clear instances where the governor has failed to in showing due deference and respect to the judge.
If your lordship want me to go into the facts, there's some disquiet about it. I didn't want to go into the facts. I assume that there is something with the court has said. I'm not even disputing the assessment of facts. I assume against myself. But even if it is so, but if you're sitting in a judgment or a review, perhaps I would have asked your lordship to go into them. I am not doing it for the time being.
Can't it be seen as a egregious situation which has come to existence? So therefore, in order to get over that, the court has stepped in to ensure it is not in the form of a laying a precedent. It is to handle a situation like
It is.
432 and 433 is handling a situation like this,
No.
in a situation where for such a long time it's pending.
What I'm trying to say is
What you carry.
the precedent value it will now emerge like this. So you can always extend this to any fact situation, minimal or otherwise, and say, now apply this law. Ask the governor to give deemed assent. The moment the court enters into this arena, then you have any kind of mind-boggling facts where the court may have to be confronted with. Therefore, I want to take it away from the fact situation and say, even if it is so, can this be done? So kindly read only one more paragraph, para 184 of the judgment. Where you get this page. That's right. Page 12333.
Just tell us the para number.
Para number, just read para number 183, then 184. Para 183 and 184. I refer to Valluri Basavaya and says the bill will fall unless the first proviso procedure is followed. Kindly turn to paragraph 183, placing reliance on the expression unless the procedure indicated in the first proviso is followed. So submitted. The decision as regards whether the procedure prescribed in the first proviso is to be invoked or not is the discretion of the governor. is only when the governor decides to return the bill along with the message that so-and-so would come into play. In other words, if the governor believes that the bill is constitutionally infirm and beyond any remedial changes, then he may choose not to return the bill along with the message and may simply declare that he is withholding assent to the bill, in which case the bill would fall through or lapse. Although the argument is seemingly lucrative and appealing, and the petition also could not provide a concrete reply to the same during the course of argument, and instead took shelter in the semantics of obiter dicta and ratio decidency, yet we deem it necessary to explain that the argument is short-sighted, half-baked, and suffers from inherent fallacy. If at all your lordships want me to give a narration of the facts, if at all it is desirable, but I don't think that would be required.
Better not go there.
That's right.
Cannot be done. Cannot be.
So I've done for the day, and I've kept certain things reserved for the reply. The learned solicitor will deal with all the other issues, and that's how we share our share of submission. I'm grateful to you all.
Wait, please. Not a very right time to begin a fresh argument. But I'll just, Lord, on the lighter side, I'm saying, Lord, your lordships are not concerned with the facts of the case. There may be few errant cases of errant governors, ministers, wrong advice, right advice, time lag, etc., etc. What is essentially, my lord, the core of the issue which is considered by your lordships, and that is something of a very, very high significance in the democracy of this country. My lord, in our republic, such question has come for the first time before your lordships, and I'm sure your lordships would not go by facts of an individual case. My lord, your lordships would be able to better advise the president only if I can show to your lordships what is the role of the honorable president and governors in maintaining a federal balance which is envisaged by the Constitution of India. Second, there may be, my lord, cases where, Lord, the Constitution has always done two things, and I will show, my lord, from the Constituent Assembly debates. Whenever we are either making a constitution or we are interpreting a constitution, we do it on an idealistic plane, that this is how each constitutional functionary would work. This is the parameters within which they would function. There may be some deviance here, sometimes in the executive, sometimes in the legislature, sometimes in the judiciary, and there is an inbuilt check and balance. But while framing the constitution, fortunately, our forefathers, my lord, the framers of the constitution were visionaries. They have examined a potential abuse also. They have kept what they are doing in mind, and each and every provision which is made is so designed that it maintains the balance. There may be some problems, my lord, which may confront, but all problems may not have a solution in the court of law. There may be several problems, my lord. I can also give illustrations of problems, but that may not be, my lord, that the problem will be ultimately solved by the judiciary. Lord, for answering this question, your lordships will have to have a holistic reading. Sorry. Lord, in a deaf and dumb school, there is a course of lip reading. Lord, I think in all law universities,
that course should be mandatorily
No,
introduced.
but I think the lawyers are experts at that.
Are experts in that.
But we can only, my lord, make a wild guess, my lord, without knowing the real conversations. My lord, for the purpose of, my lord, advising the honorable president, my lord, this is not a list between, my lord, other side and this side and that side. The honorable president is requesting your lordships to give an advice. My lord, the advice will be possible if your lordships can take a holistic reading of 5 articles.
Right?
5 articles of the Constitution. And within these 5 articles, I think, my lord, your lordships will be able to, my lord, advise the honorable president what is the correct position in law. My lord, we forget Tamil Nadu, we forget judgments, we forget facts. There may be, my lord, errant instances, etc. My lord, I'm not going in.
Fortunately, you stopped at instances
Yes, yes, sir.
preceded by Iran.
Lord, one is Article 111. Lord, that is the power of the president to grant assent. Second is Article 74. The Council of Ministers in the Union and their power, function, role, duty, whatever, my lord, we may call, to aid and advise the President of India. Third provision is Article 155, the appointment of the President, appointment of the Governor. Fourth, Article 163, which is Council of Ministers to aid and advise the Honorable Governor in discharge of his functions, and what are the differences between the power of the President and a conscious choice of words by the Constituent Assembly while defining the powers of the Governor. And last would be, my lord, this dual power, Article 200, my lord, the assent giving power of the Governor, and on reference, the power of the President of India. Lord, if these 5 provisions are, my lord, examined by your lordships, my lord, your lordships will be able to, in my respectful submission, reach a conclusion as to what advice your lordships would like to give, my lord, on several questions, my lord, most of which would be covered under this. There are certain subsects of the questions, my lord, which, of course, my lord, I will assist your lordship differently. My lord, I am treating 200 and 201 as one, my lord, group. Otherwise, it would be 6 provisions.
Part of one scheme.
Yes, part of one scheme. My lord, for this purpose, my lord, the exercise which I want to undertake before your lordships, by way of an assistance, but I am appearing for the central government, for Union of India, and we will be assisting your lordships, my lord. What is the purpose, what is the intent, and what is the object of the Constitution of India, and why a particular constitutional scheme is formulated? For doing that, my lord, what I have done is, all these 6 provisions or 5 provisions, my lord, have their history. It is not, my lord, coming suddenly, my lord, by way of a constitutional provision in 1947. It has been preceded by their perimateria provisions, my lord. First was Government of India Act 1919, when we were under the British regime. Then came Government of India Act 1935, where almost, my lord, there was a my lord, symbolic acceptance that the India will have to be given independence, and suitably, my lord, the law, though made by the British Parliament, was suitably molded. 3, Lord, there is, my lord, one draft prepared by one Mr. B.N. Rao. He was the constitutional advisor to the Constituent Assembly. He prepares draft for each and every provision. 4th, the drafting committee headed by Honorable Dr. Ambedkar, they draft a particular provision, and which goes before the Constituent Assembly, debated, and the result is what we have now as, my lord, the final provision. Lord, your lordships have my written submissions. Lord, it may look thick because my style is, my lord, I quote the relevant paras of the judgment so that your lordships may not have to suffer through.
Not required to
Suffer through, my lord, yes. Whatever I want to read, my lord, is quoted here. Therefore, it is bulky, otherwise it's not bulky. Lord, please come to article, come to, my lord, page 121.
You don't believe in one pages of Dr. Singhvi?
No, my lord.
The loose part is not necessary, you have included it here.
No, my lords. But there is a separate volume, my lord. It is 1.1, my lord, if you look. Yes.
Yes.
This. My lord, your lordships have the hard copy or a soft copy. I can use the pagination accordingly.
Same page number. You tell us the page number, it's on.
121, my lords. I think 121. My lord, first I'll take your lordships to the history of Article 111. Lord, to my knowledge and subject to being corrected, this manner of examining, my lord, what ultimately we have Article 111, that exercise is not undertaken before this honorable court. Therefore, whichever way your lordship's opinion goes, my lord, it would be relevant to bring these facts to your lordship's notice. My lord, this is peri materia or a precursor to the office of the President of India, as we understand today under Article 111. Lord, one more fact, my lord, before I reach this, and my lord, I found out, my lord, during the research of this, it may have no relevance, but according to me, it has tremendous relevance. My lord, there are several constitutional functionaries under the Constitution of India. The President of India, the Prime Minister, the members of Parliament, etc., etc. My lord, there are different oaths which are prescribed by the constitutional provision itself. It is only the Honorable President of India and Honorable Governor who takes the oath not to just not to abide by the Constitution of India, but to defend the Constitution of India. Only two functionaries, my lord. Rest of the constitutional functionaries, my lord, highest at their own sphere, but they take oath, my lord, to respect, aid and abide by the Constitution of India. These are the only two functionaries who take oath to defend the Constitution of India. Now, my lord, please see, my lord, what is the office of the President envisaged during British era. Section 68 of Government of India Act 1915, peri materia to Article 111 of the Constitution provided for. I'm sorry, page 121. My apologies.
Yeah, got it.
121 at the foot. The title is, my lord, Article 111. This is article of the present Constitution. Now comes, my lord, the history for your lordship's assistance. My lord, this is Section 68 of Government of India Act 1915. That is peri materia to Article 111. But I'll read. When an act has been passed at a meeting of the Indian Legislative Council, my lord, Lord, we can say Parliament of the day, Parliament, Indian Parliament. The Governor General, my lord, Governor General is equivalent to the President, loosely, my lord, speaking. Now, we can't compare, my lord, the colonial era with the sovereign,
appointed by the magistrate.
yes, my lord, sovereign republic, because they used to exercise the power conferred upon them and in the name of Her Majesty or His Majesty, as the case may be. Indian Legislative Council, the Governor General, whether he was or was not present in council at the passing thereof, may declare that the assents to the act, or may declare that he assents to the act. This is the first option. Or that he withholds assent from the act, second option. Or that he reserves the act for the signification of His Majesty's pleasure. So three options in the main provision, in the main part of 68(1). Then subsection 2. An act of the Governor General in Legislative Council has no validity until the Governor General has declared his assent thereto, or in case of an act reserved for the signification of His Majesty's pleasure, until His Majesty has signified his assent to the Governor General through the Secretary of State in Council, and that assent has been notified by the Governor General. There was no provision for returning the bill to the Legislative Council for reconsideration. Only three options were given. His Majesty was, my lord, like the President of India, and no, I'm sorry, my lord, His Majesty had no Indian equivalent. His Majesty was, my lord, the Crown. Governor General was the President of India, and Legislative Council was the Parliament. Now, my lord, Section 32 comes in 1934 Act, 35 Act, where, my lord, we were almost in principle, my lord, it was agreed that India will have to be made independent because of, my lord, the efforts made by everyone, my lord, who was in the freedom struggle. Assent to bills and powers of Crown to disallow acts. When a bill has been passed by the chambers, now the Parliament is present. The chambers is present equivalent of Parliament. By the chambers, it shall be presented to the Governor General, that is President, and the Governor General shall, in his discretion, please mark this, my lord. This word, my lord, is, my lord, while drafting the Constitution, is removed. My lord, something turns on that, my lord. I must tell your lordships, my lord. Therefore, in his discretion, declare either that he assents to His Majesty's name to the bill, declares in His Majesty's name. He used to do all his works in name of His Majesty, or that he withholds assent therefrom, or that he reserves the bill for signification of His Majesty's pleasure, provided that the Governor General may, again, my lord, in his discretion, return the bill. Kindly mark, my lord, two important facets. Discretion in the main section, and now, my lord, proviso comes, which is, my lord, our equivalent of 2000 proviso, 200 proviso. Just I'll come to that, my lord, but just at this stage. Provided that the Governor General may, in his discretion, return the bill to the chambers with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message, and the chambers shall reconsider the bill accordingly. Now, if the chamber does not do it, what is the consequence? Not provided. Whether it would go back, whether the Governor General can thereafter withhold, not provided. Number one. Number two, there was a discretion in the first part and there was a discretion in the second part. But now becomes a scenario of the Governor General having four options. He can grant assent, he can withhold, he can refer it to His Majesty, and fourth, he can return the bill with a message. Message can even include desirability. My lord, sometimes, my lord, in working of the Constitution, what happens is the governor sends it back saying that this particular provision might be repugnant because there is already a central act. So you may need to consider. He may also say that this particular provision might violate somebody's fundamental right, and therefore you might consider. Based upon, my lord, the situation in the state, he might even say that it would be desirable that either delete this provision, add this provision, dilute this provision, etc., etc. And then thereafter
that is provided in Article 200 itself.
200 itself now, but it was there earlier also. Desirability also, the governor can send a message. But this is how the democracy is contemplated to work, and this is how the governor-assembly relationship has been envisaged from the beginning. Now, my lord, 2. A bill reserved for the signification of His Majesty's pleasure shall not become an act of the federal legislature unless and until. Now, please mark, there was a period prescribed. Now, my lord, we are dealing with a situation where one of the questions the Honorable President is posing, my lord, for your lordship's my lord, guidance, is whether there can be a timeline prescribed. Apart from the question that by a judgment, but there can be a timeline prescribed. My lord, my respectful endeavor will be that there was a timeline, it was done away with consciously. It's a conscious omission on part of the Constituent Assembly. Within 12 months from the day on which it was presented to the Governor General, the Governor General makes known by public notification that His Majesty has assented thereto. Any act assented to by the Governor General may be disallowed by His Majesty within 12 months from the day of the Governor General's assent, and where any act is so disallowed, the Governor General shall forthwith make the disallowance known by public notification, and as from the date of notification or the act has become shall become void. Well, two things. There is a timeline stipulated for the Governor General, timeline stipulated for His Majesty the Queen, and after that, forthwith, which is a word with inherent element of urgency, he has to notify. Now, my lord, Dr. B.N. Rao, the advisor to the Assembly, my lord, when he prepares the bill for the independent India, my lord, bill was prepared when India was not independent, but India was going to be independent, because your lordships are aware the Constituent Assembly started its debates before 15th of August 1947.
In 1946.
Yes. So they were making a constitution for the sovereign democratic republic. Now, my lord, this is what Dr. B.N. Rao, my lord, formulated, which became ultimately Article 111 as we see today. When a bill has been passed by houses of the federal parliament, it was initially envisaged as a federal parliament, not only parliament, it shall be presented to the president, and the president shall declare either that he assents to the bill or that he withholds assent therefrom. There was no His Majesty, so there was no question of president referring for assent of anyone. Provided that the president may, please mark, my lord, again a time limit, not later than 6 weeks after the presentation to him of a bill for assent, return the bill, if it is not a money bill, to the houses with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and the House shall reconsider the bill accordingly. My lord, if the House does not consider his message or considers it partly or fully, what would happen? No consequence stipulated by Dr. B.N. Rao. Then, my lord, draft constitution is prepared by the drafting committee, my lord, chaired by Honorable Dr. B.R. Ambedkar, my lord. That is, Article 91 is the draft bill which came before the Constituent Assembly for debate. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. Only two options, because the crown goes. There was no third option. Now India is a sovereign democratic republic. Provided that the President may, not later than 6 weeks after the presentation to him of a bill for assent, return the bill, if it is not a money bill, to the houses with a message requesting that they will consider. My lord, same remains as Mr. Rao has suggested. There is no change. Now, my lord, very interestingly, this is debated in, my lord, the Constituent Assembly, and your lordships may, my lord, get what was the intention, object and intent of the framers of the Constitution on this, my lord, when we got 111, my lord, as we have today. On Mr. President, we shall take up the next Article 91, my lord, precursor of 111. Article 91 from the Constitution. Now, Sri Loknath Mishra, that in Article 91, for the words, well, kindly see, he suggests two amendments. There is a likelihood of some misunderstanding. Therefore, I'll read it carefully. He is suggesting two amendments. That in Article 91, the words, either that he assents to the bill or that he withholds assent therefrom, the words, that he assents to the bill, be substituted. His power of withhold was suggested to be not conferred upon him. And the following words be added. Now, second amendment he is suggesting, that is, and if the bill is passed again, following words be added in the end of the proviso to the article. When he returns with some message and it is presented before him, what should be done? Second amendment suggested by Sri Loknath Mishra is, and if the bill is passed again by the House with or without amendment, and presented to the president shall not withhold assent therefrom. This is what was suggested to be added. First was that take away the power of withholding. He can either assent or return it to the House, and if the House does something or does not do anything, he will have no power of withholding. Now, sir, in moving this amendment, I am in the best, beat is a original typo, not here. Originally it is typo, it should be best. In a best of the company, insofar as the drafting committee itself has suggested the same in a subsequent amendment. I beg to submit that when I move this amendment to take away the power from the president to dissent from any bills passed by the parliament, I mean nothing more than saying that since our president is analogous to the king in England, and as the king has no power of dissenting from any bill passed by president, this amendment is appropriate. As regards the second amendment, that is after returning by the House, second amendment, without that amendment, the proviso seems to be incomplete. Supposing the president sends back a certain bill for reconsideration and parliament comes to a certain decision, without this amendment, the whole action becomes incomplete and inconclusive. And since this is also the view taken by the drafting committee, this amendment too should be accepted. The Honorable Dr. Ambedkar, that in the proviso to Article 91, for the words not later than 6 weeks, the words as soon as possible be substituted. Lord, kindly mark this. The draft contained a time limit, and Dr. Ambedkar was pleased to suggest that remove this time limit, make it as far as possible.
As soon as possible.
Pardon?
As soon as possible.
Yes, I'm sorry. As soon as possible. It was a slip of tongue. As soon as possible. That in amendment number so and so of the list of amendments.
According to no time limit was provided. No earlier time limit was provided in the draft constitution.
It was sought to be deleted for good reasons, my lord, that ultimately the power is conferred on the highest executive. He may not be bound by the time limit that you better decide in 6 weeks, as far as possible, because we always, my lord, follow a system that highest constitutional functionaries will discharge their duties in accordance with law. They are not supposed to be. Sleep reading. Even if you're, therefore, Marad, even if your lordships do not do this, that would be fine with me, Marad.
They might hit the list.
They might. Now, my lord, Mr. Nazimuddin Ahmed, yes, sir, I beg to move that amendment number so and so in the list of amendment in the proviso to Article 91 for the proposed verb possible, the word may be substituted. I beg to submit that this amendment will make some substantial changes. The proviso is to be to the effect that the president may, as soon as possible after the presentation of the bill, return the bill, and so on. I want to make it as soon as may be. He says as soon as possible. Instead, make it as soon as maybe. It's the distinction without difference. But my lord, there were many members who always used to suggest, my lord, something just for the sake of suggesting. If we leave it exactly as Dr. Ambedkar would have it, it leaves no margin. As soon as possible means immediate.
Some members only use proxy.
Possibly, which means physical possibility is the only test. It may leave on breathing time to the president. The words maybe give him a reasonable latitude. It would mean reasonably practicable. This is the obvious implication. That is the only reason why I have suggested the amendment. Then, Manad, I come to T.T. Krishnamachari. There is a slight difference in language. I think Dr. Ambedkar's proposal will be the better one. but Dr. Krishnamachari, my lord, Mr. T.T. Krishnamachari has always, my lord, been, my lord, fair. And there were two members I come to.
He was a part of the drafting committee.
He was a part of the drafting committee. But one Mr. H.D. Kamath and someone else, my lord, he always used to oppose Dr. Ambedkar. My lord, I'll show. Appears, my lord, I write in research, H.D. Kamath. H.V. Kamath.
And Mr. Nazaruddin Ahmad also.
Yes. But he was H.V. Kamath was a brilliant, must be a brilliant man. He was an ICS officer.
Mr. Nazaruddin Ahmad also used to oppose
almost all amendments, or even the main provision of Dr. Ambedkar. Mr. H.V. Kamath was a former ICS officer. He thereafter resigned as a part of freedom struggle. Then he contested the election and lost. He challenged his election before the Supreme Court and won the matter. Again,
Hari Vishnu Kamath.
Hari Vishnu Kamath. Yes, yes. Hari Vishnu Kamath. Your lordships are right. He again won and became the member of parliament. And he was the one, one of them, nothing to do with this matter, but he suggested that travel to space should be included in the first list. He appears to be a maverick, intelligent, but he always used to oppose Dr. Ambedkar, beside the point, just as a interesting information. Then, President, I shall put this to vote. It need not be moved. Amendment number so-and-so, this is also the same as amendment number so-and-so of Dr. Ambedkar. We have taken it as having been moved. Is it necessary to move this? You can move it. Is there in some slight difference? Then Begum Azaz Rasool, Lord, I can, my lord, skip that. My lord, your lordships need not. I'll not, my lord, trouble your lordships. This is put for completeness. Then Dr. P.S. Deshmukh. Mr. President, sir, obviously the article it was worded in the beginning was found to be defective in at least two particulars, as is clear from the fact that Dr. Ambedkar himself has moved one amendment suggesting the substitution of the words not later than 6 weeks by the word as soon as possible. The second difficulty which has been visualized and which is tried to be removed is by making a provision in case the President withholds the assent. The provision intended is that when a bill is presented for a second time, it shall be incumbent upon him, that is the President, to give his assent, and he shall not have the option to withhold the assent. So far as the first amendment of Dr. Ambedkar is concerned, I do not know if it is very necessary that the amendment should be accepted. The question for consideration is whether we should merely say that the President should give his assent as soon as possible, or whether we should state any period within which he should do it. I think if the words not later than 6 weeks are to be left as they are, then it is the duty of the President to indicate his decision as early as possible and in no case later than 6 weeks. So I am not fully convinced of the propriety of changing the wording as proposal. Then, President, I would now put the amendment to vote. Do you want to say anything, Dr. Ambedkar?
Mr. P.S. Deshmukh was also the third one.
Yes, your lordships are right. And I do not know about...
He was the first agriculture minister of India.
That I did not know. Dr. Ambedkar was the first law minister.
Dr. P.S. Deshmukh was the first agriculture minister.
And the first lady was Rajkumari Amrit Kaur, first, I think, education minister.
Comet was called the enfant the terrible.
Hmm?
It's called the infant the terrible, the French word. The terrible infant.
Lord, then the President says that would Dr. Ambedkar like to say something on this? Then, Lord, many a times Dr. Ambedkar, my Lord, appears to be frustrated. Nothing more is to be required to be said. Lord, this is one of that line. No, sir, I do not think any reply is necessary. Then President, then he puts it to vote. Then Mr. President, my Lord, a bold part, there is one amendment left over. That is so-and-so moved by Dr. Ambedkar. There is an amendment to it moved by Dr. Naziruddin Ahmad. I would first put Mr. Naziruddin Ahmad's amendment to vote. That in amendment number so-and-so of the list of amendments in the proviso to Article 91 for the proposed words possible, the words maybe be substituted. Amendment negative. The President, now I put amendment 1685 that in the proviso to Article 91 for the words not later than 6 weeks, the word as soon as possible be substituted, the amendment accepted. And this is now, my lord, page 125 bottom, at page 126 is the constitution, my lord, 111. I'll read it, my lord. This is what we have right now. When a bill has been passed by the House of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. So both the options and only two options are given, because he has no option of referring to anybody above him. He is at the, my lord, peak of the constitutional framework. Provided that the President may, as soon as possible after presentation to him of a bill of assent, return the bill, if it is not a money bill, to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message. And when a bill is so returned, the House shall reconsider the bill accordingly. And if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. So, power of assent, power of withholding.
So the discussion appears to be that it has to be done within a reasonable period.
As far as possible, yes.
As soon as possible.
Correct.
As soon as possible.
My lord,
So
I may again, my lord,
some of the speakers thought that even a 6 weeks period is longer. And
no,
therefore-
don't bind him down. That is the idea.
So therefore, one of the honorable members suggested that as soon as possible, but not later than 6 weeks.
That was original. Kindly have a look. at it.
Originally was within a period of 6 weeks.
Yes, my lord.
Then Dr. Ambedkar recommended, Dr. Ambedkar suggested an amendment instead of 6 weeks, as soon as possible. So when there was a discussion on these two words, one of the honorable members said that the better word would be as soon as possible, but not later than 6 weeks.
So, my lord, in either of the cases, the President was being bound by one constitutional provision in terms of time limit. And that was, my lord, in my submission, consciously given up, that there cannot be any time limit which binds the President of India for doing something. My lord, again, my lord, at the cost of repetition, if your lordships examine the interpretation based upon, my lord, few instances which your lordships
No.
asked me.
We are not on the instances, we are on the speeches.
Yeah.
Because we can take into consideration the debates in the Constituent Assembly.
Certainly.
While interpreting the provision.
Certainly. There's no doubt about it.
Later than 6 weeks was sent by the drafting committee originally.
Originally.
How
Dr.
else
B.
do we give meaning to the expression as soon as possible?
Drafting committee.
Dr. B. Rao did not put.
Certainly, my lord. Right now, I'm not on the contentions.
6 weeks.
B. N. Rao also said not later than 6 weeks.
So then that was
That
actually
later on
the drafting committee, and Dr. Ambedkar suggested an amendment.
The point is now we have made it 3 months.
Huh?
The point is now we have made it 3 months.
Now we have made.
I leave it at that, my lord. But please, again, my lord, do not feel, my lord, in your lordship's mind that your lordships are deciding some extraordinary, my lord, or exceptional cases. That's not, my lord, the purpose of this reference. Reference will have to be decided. Every president, every governor will do their duty in, my lord, right earnest within the right time and at an appropriate stage. But he cannot be bound even by the constitutional framers by a particular time limit. That's, my lord, the point. Now, my lord, section 74. My lord, 74 is the Council of Ministers. My lord, something would turn on this. Therefore, my lord, a history would be necessary. Council of Ministers in the...
But Mr. Solicitor, the other significant addition that ultimately came out in this provision was, if you go by the original 76,
Yes,
at page 122,
yes, my lord.
where this not later than 6 weeks was there.
Yes, my lord.
At that time, there was no provision that if the president gives an opinion and desires that the House should reconsider, after that reconsideration, what will happen?
The consequence was not provided.
So that suggestion first time comes from Loknath Mishra, page
As a second amendment,
and then
which is accepted.
Begum Rasool, she also pleaded.
Well, I'll read Begum Rasul. I thought, my lord, it may not, but I must, my lord, read it.
It's worth reading.
I'm sorry.
Because then ultimately it is incorporated.
Yes, my apologies to your lordship. My lord, kindly come to page 124. Lord, I thought it
The context that after the president's opinion has been considered by the House, accepted or rejected, then there is no choice but to.
no choice. I'm not saying that. I'm not arguing against that proposition. President of India, that's not a suggestion even at the end of my submissions. The Honorable President has right A to either straightway give his assent or withhold the assent. And I'll show what is the meaning of the term withholding the assent. But if he chooses the third option of returning it to the House, whether House accepts his message, recommendation, suggestion, amendment or not, and returns it back, he has no option, he cannot withhold, he has to assent the bill. I'm making it very clear and there is no ambiguity on that. Please see what Begum Azaz Rasool said, that in Article 91, after the first proviso, the following second proviso be added. Provided further that if after the President has declared that he withholds assent from the bill or has returned the bill with a request for reconsideration of the bill or of a specified provision thereof or of any amendment by him, the Houses of Parliament should, after reconsideration of his recommendations, pass the bill again with or without an amendment and return it to him for his assent. He shall not withhold his assent therefrom. Sir, the present provision in Article 91 provides for the action that the President has to take, presumably on the first presentation of a bill. But it does not make it clear that what should be procedure if a bill is returned to the President without accepting any of the recommendations. As my lords have said, 74 is silent of that consequence. Does it mean that he can again return the bill to Parliament for reconsideration of his amendments? This will mean unnecessary delay and will mean that the bill can be returned to Parliament more than once. My object in moving this amendment is to do away with this ambiguity and to make it clear that the President can return the bill to Parliament with his suggestions once only. But if the Parliament does not agree to the amendments that are suggested by him and returns the bill to him, he should not in that case return the bill a second time for the reconsideration of Parliament. In the House of Commons, any bills which has been passed twice by the House of Commons automatically becomes law, even if the House of Lords disagrees. In the same manner in USA, a bill becomes an act even if the President vetoes it, provided it is passed by 2/3 majority of the Congress. Some such provision should be made here in this article also, so that unnecessary delay may not take place. With these words, I move the amendment. This is accepted, my lords are right, my lord, and I should have read it, my lord. Now, my lord, kindly come to page 126. My lord, we are now Article 74. That is, there shall be aid and advice of the Council of Ministers. Lord, please have a look at, my lord, what was the position in 1935. My lord, this came for the first time. It was not there in 1990. This has come in 1935. There shall be a Council of Ministers not exceeding 10 in number to aid and advise the Governor General in the exercise of his functions, except in so far as he is, by or under this Act, required to exercise his functions or any of them in his discretion. This was there. Correct, Lords? Provided that nothing in this subsection shall be construed as preventing the Governor General from exercising his individual judgment in any case where by or under this Act he is required so to do. Under this Act, my lord, now this has gone, my lord, I'll come little later. The Governor General in his discretion may preside at meetings of the Council of Ministers. If any question arises whether any matter is or is not a matter as respects which the Governor General is, by or under this Act, required to act in his discretion or to exercise his individual judgment, the decision of the Governor General in his discretion shall be final, and the validity of anything done by the Governor General shall not be called in question on the ground that he ought not to have acted in his discretion or ought not to have exercised his individual judgment. My lord, thereafter, my lord, the first draft is prepared and Article 55 of the first draft, my lord, there were two, orally, my lord, I'll point out, there were two committees constituted. One was Union Committee within the Constituent Assembly. Another was Provinces Committee. Union Committee was headed by Pandit Jawaharlal Nehru ji, and a Provincial Committee was headed by Sardar Vallabhbhai Patel. And they both, my lord, Nehru ji decided the All India structure, and Sardar Patel's, my lord, committee not decided, but they recommended how the states, and they used to be known as provinces, how the states would function as a part of the overall federal setup which we have envisaged. It's not a federal setup, as understood in America, that every state is as such independent with its own Supreme Court, etc. We have a different...
Its own constitution also.
Its own constitution. The governor is the chief, my lord, in American states. We have, my lord, a different collaborative kind of a federal constitution. Now, when Mr. B.N. Rao, my lord, prepared Section 55 is his, my lord, function. There is his version. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President in exercise of his functions. After a detailed scrutiny, now draft, I'm skipping reading. 61 is what the drafting committee drafted. 61, my lord, at page 127, your lordships have. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. Your lordships would notice the discretion, exercise of powers in his judgment, which was there earlier with the Governor General, is now not available with the President of India. He is supposed to exercise the powers as per aid and advice of the Council of Ministers. The question whether any, and if so, what advice was tendered by ministers to the President shall not be inquired into in any court. Please mark this, my lord. This is the sanctity given to the Minister-President advice, that it is immune from examination even by the courts. There are provisions made under the Constitution where some of the executive acts and legislative acts or quasi-legislative acts are made immune from the scrutiny of the court. That's the balance, my lord, of separation of powers, which I'll ultimately, my lord, assist your lordships with.
9th schedule.
Yeah, yes. Other than 9th schedule also, there are certain issues where the Constitution bars any judicial scrutiny. That's, my lord, the fundamental principle, my lord. Then, my lord, how this, my lord, was debated. Yes, my lord, this is how, my lord, this article was debated in the Constituent Assembly. Mr. Mohammad Tahir, Mr. Vice President, sir, I beg to move that at the end of clause 1 of Article 61, the following be inserted. Except insofar as he is by or under this Constitution required to exercise his function or any of them in his discretion. So there was a suggestion that the discretion which is taken away from 1935 Act should be restored. If this amendment is accepted, then the article would read thus. Lord, I'll skip that. Now my second amendment is as follows, that the following new clause be inserted after clause 1 of Article 61. Article 61 is, my lord, precursor to Article 74, present Article 74. And the existing clause 2 be renumbered as clause 3. If any question arises whether any matter is or not a matter as respects which the President is by or under this Constitution required to act in his discretion, the decision of the President in his discretion shall be final, and the validity of anything done by the President shall not be called in question on the grounds that he ought or ought not to have acted in his discretion. Again, my lord, restoring the position of 1935 Act. The Governor General had this discretion, and that discretion will not be called in question, was sought to be amended, my lord, or suggested to be amended while framing the article. In moving these amendments, I want the President of India, although he is a nominal president in the words of my honorable friend, Mr. Kamath. Kindly pause here for a minute. Mr. Kamath always says he is a nominal president. And rest of the, including Dr. Ambedkar, they say that this is a different indirect election method we have adopted. Unlike the queen or king, he is not a successor. He doesn't get his office by succession. He is an elected person, elected by indirect representation of not only the parliament, both the houses of parliament, but even the state legislatures. So he represents the legislative and democratic will and mandate of the entire nation by way of an indirect election, unlike in USA where there is a direct election of the president. But Mr. Kamath has chosen to describe the Honorable President as
comparing him with the American president.
Yeah, yes.
Because in American president, all the powers are vested with the American president.
Yeah, yes.
Here, the president has to act
on the aid and advice.
Fully on the basis of the aid and advice of the Council of Presidents.
Yeah, yes.
His difference would be in that context.
Yes, but he says there is a nominal president. He always, I don't wish to go into it because it's not necessary, but he always found that he is not an elected person. He is not an elected person. That's how he understood it. And my lord, it would come somewhere, my lord, in the debate that he is an elected person. He represents the will of the nation, maybe by way of an indirect election. I elect my MP and my MP elects the President of India. He represents me.
That's why we are a republic.
Pardon us?
That's the reason why we call ourselves republic.
Yes, exactly. That's the very heart and soul of the term republic. In moving these amendments, I want that the President of India, although he is a nominal president, in the words of my honorable friend, Mr. Kamath, still I want that the President should not be tied down all around. At least this House should be generous enough to give him the freedom of using his discretionary powers. In introducing this exception, I would submit that it is not a novel exception. If you will be pleased to look at Article 143 of the draft Constitution, you will find that the same exception has been allowed in respect of governors and the ministers of state. The governors still continue to have this discretion, and there is a debate why that discretion is conferred on the governor. That is essence of the federalism, which has a unitary tilt. But at the same time, the governor is supposed to exercise certain other functions, my lord, and therefore that discretion continues with the governor. When the governor of the states have been given power to exercise certain powers in their discretion, I do not see any reason why this innocent power should not be granted to the President of India. I need not make any long speech in this connection. I close my speech with the hope that my honorable friend, Dr. Ambedkar, will consider this question seriously and decide in favor of my amendments. Then, my lord, amendment is negative. The discretion does not remain now in Article 74. Well, this amendment suggests earlier was there in 1935, not there in the draft article, sought to be inserted and not conferred. Now, my lord, final draft as it stands today, there shall be my lord, on page 128, there shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in exercise of his functions, act in accordance with such advice, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. So he can send it once, but if it comes back from the Council, he is bound. The question whether any, and if so what, advice was tendered by the ministers to the President shall not be inquired into in any court. But again, a constitutional bar against any judicial oversight. Now, my lord, Article 155. Lord, this is appointment of the governor.
And so far as the president is concerned, only instance where for a long time bill was pending is perhaps the postal bill during Jain Singh.
Your lordships are right. Lord, there are
for a long time.
Lord, some of the bills were withheld but right from our entire journey from 47 onwards, 20, 30 bills are withheld. But when we see, we find that they were rightly withheld. For example, one bill was that in state of, I will not name the state, my lord, in one state, the assembly passed an act that before registering yourself in the employment exchange, you have to take permission of the state and you have to be a man of that state, resident or domicile of that state. The president said you can't do this. So there were several, few instances, but where bills were withheld. But as my Lord Justice Narasimha says, the longest period was the postal, and it has its own history. I will not go into it, but some good justification. Years back, it's not a current.
Keep reading.
No, I am not trying even. I don't know, my lord. Therefore, I am not trying.
You soon learn that art.
Now, my lord, comes Article 155. My lord, I'll take some time, my lord. I'm not repeating your lordship's.
No, we are not saying so. My learned brother asked, because there are only 7 minutes left.
Lord, the next point is an important point. Can I start tomorrow?
That's what.
Because 155 is appointment of the governor. What is the significance? What is the role envisaged? What is the responsibility he is expected to?
We understood your desire, and so accordingly, tomorrow.
We also have to now do some other work for at least next 3 hours.
Yes, yes. Your lordships need not read this. Otherwise, my lord, it would be very boring. I am going to read this.
No, we are having at least 3 of us are having some other duties.
I leave it to your lordships, but in a presidential reference, except state and my lord,
Private parties.
The exact opposite of that.
There is one line, one line. We are given the deadline, we should have filed prior to that. Necessarily, we will hear you.
grateful to you.